Hello and welcome to the Rogers Brief for June 23rd, 2023. I'm Adam Rogers. Thank you for watching and thank you for listening. This week we're going to be covering some cases out of Nova Scotia, a variety of cases, one involving the Legislature and some MLAs, another with an estate claim, one with a criminal court case involving the sexual assault allegations, but on an evidentiary perspective is what I'll be talking about. And then finally, a building on First Nations land, which has become the subject of a dispute. A couple of national cases, too, I'm going to talk about, following up on a story I talked about last week of the judge shortage in Canada, Nova Scotia, but it's across the country where this has become an issue. And a lawyer out of Ontario has tried to take some legal action to address that shortage. And in addition, the other thing I'll talk about is the federal government released their action plan on the United Nations Declaration of the Rights of Indigenous Peoples, and this was released on Indigenous Peoples Day this week. So the first thing I want to talk about, though, before I get into those stories, is we're going to be holding a special book launch and discussion event on Tuesday evening, 9:15 p.m. It'll be live on YouTube. And Jordan Bonaparte from the Nighttime Podcast, people that watch these videos and know that I go on the Nighttime Podcast many Sunday evenings and talk with Jordan Bonaparte and Paul Palango about the mass casualty events, the fallout, the different issues that are surrounding that. Well, Jordan is going to be the sort of host / moderator of this discussion, and I'll be reading a little bit. I'll read a few minutes from the book and talk about what's in there, some of the thinking behind it, and why I wrote it and why I think it's an important book at this time in our history. So anyway, look forward to that discussion with Jordan and presentation to you. And I would say I've got a link for the book. It's easy to find the links to the book, but you wouldn't have to have read the book. The plan is that you won't have had to have read the book in order to enjoy the discussion. And the discussion will be archived as well. You can join live and make comments and ask questions in the YouTube chat. And you can also view the archived version at a later time, or the podcast version. I'll be uploading it as a Spotify and Apple podcast as well. So people will be able to get it there. It'll be about an hour long, give or take. And so hopefully that's something that people will enjoy. Okay, so that's that. Look forward to seeing everybody Tuesday evening. In addition, Sunday evening, I'll be on with Jordan and Paul for the Nighttime Podcast. All right, so first story. This is following up on a story last week, which was about the judge shortage. And I talked about Nova Scotia and the provincial court. There's a few judges short. Well, across the country in superior courts, so Supreme Courts and Courts of Appeal, there are 79 vacancies. Most prominently in British Columbia, there's 13 vacancies. Ontario has 24, larger provinces, but still that's significant. Nova Scotia has 3 vacancies, one in the Court of Appeal and one in the Supreme Court, one in the Supreme Court Family Division. So that's not insignificant, and it's delayed some cases and led to some offenders or led to some accused having their cases stayed by the Crown as a result of unreasonable delay. Well, this law firm out of Ontario, out of Ottawa, Hamed Law, is taking action, or trying to take action. Nicholas Pope is the lawyer whose name is on it, but the applicant is Yavar Hamed, who advertises himself as a human rights lawyer, and that he's representing clients and their cases are being delayed, and there's not enough judges, so things aren't being heard. And what he is what they are seeking, in addition to the publicity coming from getting this case in the news, which is where I saw it, so good for Hamed Law for getting some publicity out of it, but what they're seeking in official terms is a writ of mandamus. What is that? Well, you look to Black's Law Dictionary. Mandamus is Latin for we command a writ issued by a superior court to compel a lower court or a government officer to perform mandatory or purely ministerial duties correctly. Okay, so writ of mandamus, so that would be a demand, an order that the government appoint judges in these ways now, or in the alternative that there be a set time frame within which judges should be named or must be named. Don't really see that application being successful. There's a separation of the courts and the government, and I don't think the courts will accept, in a sense, that the government is hamstrung, tied to certain time frames without other considerations. But we'll see. We'll see where it comes along. Certainly, the publicity from this application, I suspect, will spur some governments on to, the federal government in particular, who names these Superior Court justices, to get moving. Surely it's a sign of competence that you're able to make appointments like judicial appointments in a timely manner and keep the access to justice and the justice system generally going smoothly. Okay, that's one federal issue. Second one, federal government released on the first day of summer the UN Declaration of the Rights of Indigenous Peoples Action Plan. Now it's 74 pages long. I read through most of it. It's what you would expect, in a sense. Lots of aspirational language about the relationship between First Nations and non, and how that should work. By the way, I talked about this a few months ago when I was talking about the electoral boundaries disputes here in Nova Scotia, and Jaime Batiste, the Member of Parliament for Sydney Victoria, raised the legislation the federal government, the Liberal government, had made regarding the UN Declaration of the Rights of Indigenous Peoples, that they adopted the United Nations Declaration and sort of tied themselves to an action plan. Well, in the electoral boundaries dispute, Jaime Batiste tried to raise the UN Declaration as sort of a defense, in a sense of, well, you can't move First Nations around without consultation. And Justice Bourgeois, who I'm going to get to later because she was involved in one of the decisions I'm going to reference, wrote in response that the government hadn't even implemented or hadn't even adopted an action plan as contemplated by the legislation. So how can you reference that if there isn't even one in existence? Well, there is now, and notably, it does not contain anything about electoral boundaries or electoral representation in that way. So that part's interesting. The other one, David Wright, a former classmate. I think actually, David was a year behind me in law school. He's now teaching at the University of Calgary, teaching law there. Wrote about the modern treaties section. Interesting little article. He writes it's AB Law blog out of the University of Calgary, talking about how now the government has what he calls an ungenerous interpretation of these modern treaties and treats them more like a commercial contract than a relationship document, a relationship, framework document, as is what treaties are typically interpreted to be. And this new policy in Professor Wright's interpretation is seeking to change that into more of a relational treaty-like situation. So, and he references an interesting sort of analogy that on the government side, they see treaties as a divorce. In other words, okay, we haven't been able to work together, so we'll write this agreement. You do your thing, we'll do our thing. Whereas First Nations see these treaties as a marriage. Like, all right, we have decided to or need to live together, work together. So this is how we're going to do it. Here are the terms under which we're going to engage in this relationship. So seems like a better way to look at things as in marriage, but certainly an interesting analogy of the two perspectives that are held. All right, so those are some national issues that I thought caught my eye in the last few days, and I thought I'd bring to your attention. So Nova Scotia specific cases. The one that was it's not a case yet. It's apparently a claim has been filed by Elizabeth Smith-McCrossin, the independent MLA for Colchester North. Some controversy in the spring session when she was raising non-disclosure agreements, and this was an issue that came up, and there was an allegation by Miss Smith-McCrossin that the government had made a former staff member of hers sign a non-disclosure agreement. Government denied it, and then MLA Smith-McCrossin persisted, and the government made a motion, introduced a motion in the legislature to expel Elizabeth Smith-McCrossin from the legislature. So Elizabeth Smith-McCrossin, is now applying to the Supreme Court to declare that motion null and void. It was never voted on, but it's still there. It could be voted upon at any time. Now, the House is not sitting, so when the House sitting resumes, that motion could be called for a vote at any time. So it's sort of hanging over Elizabeth Smith-McCrossin in a sense, and she doesn't want that. So I haven't seen the actual court application that she has made. I suspect what she is going to be saying is that there's nothing in the House of Assembly Act or in the rules and forms of procedure that allows such a motion over basically a disagreement, even if it's a factual disagreement, and even if it's a disagreement where an independent member persists in making it. So she's correct if that's the case, because there is nothing in the House of Assembly Act. I mean, there's things to disqualify a member, but they have no application that, if you just disagree with the government in some sense. Same with the rules and forms of procedure. There's conduct rules, but that is something that the Speaker rules on. The Speaker can remove somebody for up to 5 days. So procedurally, it would seem the most appropriate for this situation to be resolved by the Speaker of the House. Again, but on the other side, so in a sense she has a good case, because there doesn't seem to be authority to just make a motion and remove a member without the approval of the Speaker, or without the really initiation of the situation from the Speaker. Second is, but on the other side, if a motion is improper, there are rules within the House rules that says the Speaker rules on that. So the government might be able to go into court and say, well, this is not a motion, or this is not an application that a court should hear. This is something that the legislature itself should decide, which is, I think, where this will end up, perhaps back in the fall. Anyway, we'll see if these documents become available and can look through the claim from Miss Smith-McCrossin, and it'll be interesting to see the government's defense as well when that comes out. All right, next case. McCallum versus Langell Estate, and this is a Nova Scotia Court of Appeal decision from Justice Bourgeois. These were self-represented individuals from the estate and Mr. Claude McCallum. Now, what happened here, the application itself was looking to extend time to file an appeal book. Appeal book, by the way, a very thick book which contains all of the trial record, any exhibits that were brought in at trial. So it's a lot of work to put together an appeal book. Mr. McCallum was 2 days late filing it, so he applied to extend the deadline and allow that to go through. Well, the Justice Bourgeois had to decide if that was appropriate, and in the course of deciding whether it was appropriate, you have to decide whether there's any realistic case to be made on behalf of Mr. McCallum against the Langell Estate. Well, who's the Langell Estate? That's Cora Langell. Signed a will in 2014 with 3 beneficiaries, including her daughter, Shirley McCallum. Now, Shirley McCallum and her mother were estranged, and Shirley, the daughter, was terminally ill, didn't think she was going to survive her mother, and in fact did not. Prior to her death, Shirley McCallum wrote to her mother saying, I know I'm a beneficiary, and we've had our hard times. What I would like you to do is assign my interest to my husband and let him look after that, and he'll handle it appropriately or something to that effect, right? So trying to get her to pass it on to her husband. Mother did not do that, and so the estate went to the two other surviving beneficiaries. And so Claude Langell took action to say, Claude McCallum took action to say that was inappropriate. Well, this is what happens when you're self-represented. I mean, this was a very clear-cut case in a sense where, because Claude says, the phrase, those there then living, was the estate's quote-unquote only defense. And the court said, yes, that is their only defense, and that's all they need. You only need one defense if it's a good one, and if it's clearly makes your claim. Court says that it was clear and unmistakable, her intention, that is, in her will, and that even if the legal outcome conflicts with what Mr. McCallum believes is right, then that's too bad for him. So a lot of wasted time and expense going through this process. Should have been clear up right away to Mr. McCallum if he had received legal advice that he had no chance. It was just a request from a beneficiary so a request, the overall principle. If you're a beneficiary and you make a request to the person writing the will, hey, why don't you do this with my share if I don't make it? It's meaningless. It's still up to the person writing the will to write what they want to do, and that's what's going to hold. All right, next case I want to talk about is a criminal case involving a Mr. Roter out of Halifax. And this was a decision from Jamie Campbell. And Mr. Roter was found not guilty of sexual assault, of rape. The issues were, there was two decisions released this week. One was a decision on the main claim itself, on the case, and where Mr. Roter was found not guilty. But an earlier one was an evidentiary issue, two of them. One was, could text messages between the two individuals, Mr. Roter and the alleged victim, could they be used in trial? And secondly, was it legitimate for Mr. Roter, Mr. Roter's lawyer, to ask the complainant about a prior sexual encounter that they had had? Well, because normally there's lots of rules about what you can ask about prior sexual encounters, and the reason is the courts don't want to have, you bring up somebody's sexual past in a way that says, well, since they did this and this and this and consented at that time, they probably consented this time. That's an inappropriate use of prior sexual activity, and that's not to be allowed as evidence. In this case, it was different, and he was allowed to ask about the prior incident because it was between the two of them, and it was, some weeks prior, and the police had asked the complainant about that other night, and she said, no, we just watched a movie. Roter said, no, we had sex, and described it, and so it wasn't to try to show any propensity that she had to sexual activity or try to suggest that, well, she consented then, so she probably consented now. It was to attack her credibility. She lied this time, so she might be lying now. So that's a different way of using prior sexual activity, and it's a legitimate use of it. The other was the text messages between the two, and there was so text messages are often used in court. That's not unusual. There were some sexually explicit text messages, and the Crown and the alleged victim took the position that, well, these explicit messages are, I think they initially took the position, these sexually explicit text messages are records, or they are considered sexual activity in themselves. And so special rules would need to be applied. Eventually, they all agreed that they could be used, and the judge agreed with that too, but he had to go through the steps to make sure that those were appropriate. So not always the case that you'd be able to use sexually explicit text messages, particularly if the messages were not between the two individuals thought to be involved in the current sexual activity. All right, so that was R versus Roeder. The decision went through this in some detail. A couple had met through Tinder, and so one of the other things that Justice Campbell made a note to himself was that the manner of communicating and the language used to communicate, that a justice who is at least a generation removed from the technology and the sort of dating scene technique should be cognizant that the language is going to be different, and that the justice should be, I guess, flexible in a sense of trying to understand what those language parameters in a certain app may involve that would be different than you might see or you might expect in face-to-face contact or communication by older individuals. So that was an interesting element of the case too, actually maybe the more interesting element. All right, last case I want to talk about is this case out of Sipekne'katik First Nation, and it involves the band versus Mi'kmaq Family and Children's Services. This was a Court of Appeal decision as well, written by Justice Fichot. The panel was Justice Fichot, Chief Justice Wood, and Justice Derrick. So in, a little over 10 years ago, almost 15 years ago now, Mi'kmaq Family and Children's Services built a building on the Sipekne'katik First Nation, and they've occupied it ever since, or they occupied it until November of 2021. There was no lease signed, drafted, or no rent paid during that whole time, during the 10 years or so that they were in the building. But they paid for it themselves. Mi'kmaq Family and Children's Services paid for the building. So in November of 2021, Sipekne'katik First Nation tells Mi'kmaq Family and Children's Services to vacate the building, which they did. They did that within, I think, a month or 2 months. But now Mi'kmaq Family and Children's Services is claiming for unjust enrichment. In other words, we built this building, we thought we'd stay in this building in perpetuity, yet now you're kicking us out and not compensating us for the expenses. So now Sipekne'katik has this nice new free building, and that is an unjust enrichment. So a good claim, it would seem, and it seems as well that the parties are trying to negotiate a resolution. I get that sense, because this is not an application, this is not a decision on the main claim about what the value of that building is and whether it is indeed unjust enrichment. I'm sure it is, and will be seen that way, and there'll have to be compensation for the building. But I think what Sipekne'katik is trying to do is figure out, well, what would have been a reasonable rent over the course of those 10 years and reduce the amount owing by that reasonable amount of rent. And what they're trying to do is get some records from Mi'kmaq Family and Children's Services from two other buildings they have, one in Bear River and one in Eskasoni, and see, all right, what are you paying for rent there and what are the arrangements? Well, Mi'kmaq Family and Children's Services says those records are not relevant, and the court agreed. They are, first of all, those other two leases, there are leases and there is rent being paid in the other locations, but those were drafted after this building was built, after Mi'kmaq Family and Children's Services started occupying the building rent-free without a lease, and so they would have had no effect on any of the discussions throughout the relevant time frame. So in other words, these documents are not relevant. And so Mi'kmaq Family and Children's Services was successful in the application. Court of Appeal agreed with that. They did not agree with the applicant. Sipekne'katik, represented by Mary Rolfe from Pink Larkin, and it was Dennis James and Anne-Marie Manley from Patterson Law in Truro and Halifax for Mi'kmaq Family and Children's Services. So interesting case there. All right, so those were the relevant cases and issues that I thought would be bring to your attention this week. Hope everybody enjoyed that. Again, just invite you to join us all on Tuesday evening at 9:15 p.m. There'll be a link in the YouTube channel to check in. You can even get it so that you're notified in advance if you need a reminder for that. So look forward to all that and discussing the book that's here. And until then, I want to thank everybody for watching, thank everybody for listening, and we'll see you next time.